Hi, and welcome to the second Zoominar in our series of Zoominars providing legal and financial tools to physicians. I'm Safura Khan, an attorney from Cornerstone Law Services, and my partner, Hani, and I are married to physicians, and we understand that there are specific issues that affect this particular part of society. So we wanted to make legal and financial tools understandable and accessible to all of you. Throughout the series, we will be discussing ways to organize your assets in living trusts and inventory sheets, protecting your assets by structuring them in segregated entities that make sense to your particular situation, to protect them from potential lawsuit risks from within or outside of your practice, how to structure your practice in order to minimize taxes, the best ways to set up insurance for your practice, investment strategies, including several real estate and conventional investments in order to grow your assets, and how to pass on your assets to the next generation maximally and efficiently. We will be bringing in experts to allow you an opportunity to learn from and ask questions from people who have extensive knowledge in all of these critical financial areas. Today we have Don Gary, a tax and business attorney with decades of experience in sophisticated tax, estate planning, and business law, asset protection, entity selection and formation, contract review, and business succession. And representing physicians today, somebody I know is Dr. Sana, who I kind of know. But anyway, he's a radiologist specializing in musculoskeletal injuries and TBI diagnostics in Southern California. Today, they will be discussing the optimal way to structure your practice, whether it's a solo or a group, so that in case of the unthinkable, it can be passed on efficiently. But before I hand it to them, Hani from Cornerstone Law Services will be providing some background info on this topic. If you have any questions, please post them in the Q&A area located at the bottom, and we'll try to get to them at the end of the Zoominar. Hani?
Yes, sounds good. And I just wanted to go ahead and share my screen real quick. Okay, hope you're able to see it. And I'd like to start basically with some of the few questions that we received from some of the doctors that emailed us over last week. And briefly, we wanted to basically, one of the questions was, will a professional corporation protect my family? Another question is, can I put my professional corporation into my joint revocable living trust that I set up with my spouse? And you know, one of per California law, ownership rights of a professional corporation can be transferred to a trust if the trustee and beneficiaries are all licensed. So otherwise, only the individual who holds the professional license can own shares in a professional corporation. And transfer these shares can only occur to another licensed individual or professional corporation. And that basically leads us to today's agenda. And I listed the three most common questions that we received from the doctors. Basically, if according to California Corporation Code Section 13407, if only physicians can own shares in a professional corporation. So first question was, how are physicians' own group and solo practices passed on to non-physician spouses and children? Question number two is, how can you ensure that the unexpected death of a physician in a group or solo practice does not mean there will be a significant effect on the care of patients? And the last question that we're going to be tackling in this webinar, how can you make sure your non-physician spouse and children do not have to close or sell the practice at a lower value? And now I want to pass it along to Dr. Sana Khan and Gary to basically share with us.
So Gary, as you Don, as you actually address some of these questions, I think I'd like to ask you whether these same questions are going to apply to other professions as well. So I know that other professions such as law, maybe even a CPA practice or other practices, dentist practice, are they also subject to very similar situations where a license holder of that particular profession cannot have shares in that professional corporation. So I know we're talking about doctors here, but I'm also interested whether this is applicable to other professions as well.
Thank you, Dr. Sana, and it's good to see you again a week later. And so the answer is yes, there are some differences, but if you're a licensed professional, and so we're talking about accountants, we're talking about engineers, we're talking about physicians, dentists. If you're in one of these groups that's a licensed professional, basically California law says that the only owners of these kinds of businesses can be the licensed professional themselves. It can't be anybody else. And so the issue of who can own the practice is similar. However, there are some areas that are completely dissimilar. And that has to do with what can the non-professional look at? What can the non-professional see? And so, for example, when we're talking about physicians, we have to deal with the HIPAA issue. If we're talking about lawyers, we have to deal with the attorney-client privilege issues. And with the lawyer's files, there's attorney-client privilege. And so there's information that's just not allowed to be disclosed to anybody else without the client's permission. If we're talking about CPAs, we may have some confidential matters in there, but we don't have kind of the same type of a privilege that you would have if you were a doctor or a lawyer. And so there's a little more or a little easier to get in and maybe take a look inside the actual business itself. Same with engineers or other services. So we really have an interplay of a number of different kinds of laws when we're dealing with these different groups. But the basic core idea is the same. If you don't hold the license, then you can't practice in the profession, period. And if you attempt to practice in the profession, so if you're the spouse or the brother-in-law or somebody and you attempt to continue to run a professional practice, you run some serious sanctions for the unauthorized practice of medicine or the unauthorized practice of law or the unauthorized practice of accountancy. So it is a very, very, very important issue that we need to deal with. This is not like owning a real estate company or owning a machine shop or owning a factory. It's a completely different issue, and one that really needs to be addressed because of the nature of the practice, because of the limitations on who can run the practice and who can't run the practice, there's a real substantial risk that the value of that practice will wither away in very, very short order. There's a very significant risk that you, the physician, or you, the lawyer, or you, the accountant, have built up a tremendous practice, a very, very valuable practice, one that's generating significant recurring income for you and your family. And then all of a sudden, well, think about it this way. Have you ever gone out garage sailing? And have you ever walked into that garage sale and there's that set of golf clubs, and I'm sorry, but the widow just has no idea what they are or what they're worth, and you're buying. I had a young man that I know down in Florida, and he was a high school golfer, one of the best golfers in the country for his age, one of the top 1,000 anyway. And he used to do that all the time. He'd go to garage sales, he'd find golf clubs, he knew what they were, whoever was selling them didn't. He'd pick up a bag of clubs for $10. He'd go back home and sell the driver for $200. And so the same thing happens here for us in a different kind of a way, in that I die, my wife can't run my practice because, well, she didn't go to law school. She was smarter than I was, I guess. But now all of a sudden she's stuck with this white elephant and there's nothing she can do with it. And the next lawyer that comes along might be willing to offer her 10 cents on the dollar, or maybe not. And so that becomes an issue, and one that absolutely requires planning ahead of time.
I see. Okay. All right, then let's talk about the doctors and see what kind of planning they need to do.
Well, let's take a look at what's going to happen if a doctor dies. And let's look at, the first thing we'll look at is a solo practitioner. So we'll look at a solo. What happens when that doctor dies? And so basically, when the doctor dies and there's nobody else to take over the practice, we have a number of steps that have to take place. We have to notify the California Medical Board of the physician's death. Right away, we need to notify the Federal Drug Enforcement Administration, and we need to get some instructions about what we're going to do in case we have any drugs or controlled substances and how they're to be handled. We've got bills to collect. We've got debts to pay. We've got patients to notify, because if I get hit by a bus today, there's going to be people that are coming into the office tomorrow. Those folks need to be notified as quickly as possible, because there'll be nobody there for them, nobody at all for them. There's people that are going to come in as time goes on. How can we protect the value of this practice? Every day that it doesn't get sold, it goes down in value. It doesn't go up in value. It can never go up in value. And so every day that it's not sold, it goes down in value. So who's going to sell that practice? Are we going to go through a business broker? If so, are we going to be able to find a business broker that knows how to sell medical practices and how to preserve the value in those practices? Do we even know who to call? Have we worked with anybody? Have we talked to anybody? What about patient notification? And so as soon as we have a physician die, we've got to let the patients know what's going on. They've got a right to their file. And we have some interesting issues with those medical records, because who has the right to even open the file and take a look in there? Who can take a look at anything without violating HIPAA or potentially violating HIPAA? And so we've got some issues and some problems that we have there. Do we need to hire somebody else? Do we need to hire another physician to come in just to be able to get through the process of notifying the patients so that they can go ahead and request that their file be transferred to somebody else if that's what's going on? We've got employees. All of a sudden, employees are out of work, because if the practice isn't going to continue, what's going to happen to those employees? Who's going to notify the employees? What are we going to do? How big is our practice? How many employees do we have? Do we have any other issues that we need to deal with, such as WARN Act issues or any of those other kinds of issues if we're big enough? If we're smaller, we still have the issue of what are we going to do with these employees? Do they have any COBRA rights? Do they have any other rights? And who's going to handle that? Who knows the practice? If there's a manager, if there's an office manager, the office manager probably knows the practice better than anybody else. And so we want to keep the office manager on as long as we can, particularly if we have to wind down the practice, or if we want to preserve it as well as we can. We need that office manager there. But the office manager is thinking about themselves, and they're thinking about, okay, what's next for me? And how long can we keep that person on? How long can we keep them under contract when they're worried about what are they going to do in 6 months or something like that? So can we reasonably expect to keep them on? And if we're going to keep them on, what's that going to cost us? Because if I'm a really good office manager, am I going to stay around at what knowing that I'm going to be out of work in a couple of months anyway? Or is it better for me to start looking down the road, and where does that leave the estate? Leaves the estate potentially in a lurch. And one of the things that I see here, it's kind of an interesting picture, imagery, if you will. And it says, patient records are like nuclear waste. If you think about it, nobody wants the patient records. Nobody knows how long they're supposed to store the records. We do have record retention laws. Nobody knows where to store them. Nobody wants to have to pay for storage space, those other kinds of things. I mean, the absolute best option is if there's a physician that would be willing to take the patients and the patient's records. But they might pick and choose too. And so if we haven't done anything about that, we've created a real problem. And we have these problems. Do the people we have in place, does our spouse, do our children, does our best friend, or even our lawyer or accountant even know about these issues, even know what to do with respect to these issues? Because there's some liability issues that are hanging out there. The physician is still on the hook for any malpractice claims that might have been made. Now, there is a shortened period of time to bring a claim against a deceased person, and that shortened period of time in California is 365 days. But still, there's that possibility that there could be a claim for malpractice within that period of time. There's also the rights that various and sundry folks would have in the records, the patient themselves, representatives of the patients, lawyers, other people that might want to look at that. There aren't really good answers. So there's not any kind of a specific rule out there that says you must keep the records for X days. There's different issues. There's different statutes of limitations for different kinds of things. And so, you know, what if you got patients or records of younger patients and they're going to need those records continuing going out throughout their lifetime? We also have the malpractice insurance issue.
Yep.
You probably can't get more malpractice. We might need to look at buying a tail depending on the nature of the practice. If it's a high risk practice, we might need to be look at buying a tail in case there's a later claim. But we certainly don't want to cancel the insurance that's in place, because we want to at least let that continue to run out through the policy period, because most of the policies that we see now are claims made policies, which means that if you have insurance when somebody comes in and makes a claim against the professional, then there's coverage. So
wait, Don, I'm sorry, wait. Are you saying that even after somebody dies, that they need a tail coverage, or their assets potentially could be at risk?
Well, let's look at it this way. All right, let's assume for the sake of the argument that you die right now. And then let's assume—
Can we just kill Hanny or something instead of me? I mean,
we could, but he's not a doctor.
Oh, okay.
So you die right now. You die right this second. Okay, and today is what?
Okay, why is Sephora smiling? What's going on with that?
Because we haven't done your estate planning and all your assets are community property, and she just won the lottery. That's why. But
Fine. Okay.
But, you die today. Today is August the 10th. Your policy, your malpractice policy has a September 1 renewal date.
Right.
But you're exposed to malpractice for 365 days. And so the policy that you have in place right now is going to end on August the 31st.
Right.
I can sue you because, you know, you cut off the wrong fingernail.
Yep.
In December or in January or February.
Right.
It's the tail issue.
Right.
Now, in some practices, it's not that great a risk, but in other practice areas, it's going to be a much greater risk. That's going to be one of those decisions that's going to have to be made.
Right. So, but my spouse didn't know that she needed to pay for my malpractice insurance tail, whatever it was, in September 1st. So when you sue me, are you now suing my estate?
You are, or your trust.
Or my trust?
Or your trust. So there's some exposure there. And these are things that people aren't aware of, people that don't know about these issues, and they can come up. So what do we do if we're this solo? Optimally, if we're going to be a solo, we're going to take one of two possible routes. The first possible route that we have is that we're actually going to have a relationship with another physician or another group of physicians that they would be willing to step in and buy my practice at some fair and reasonable value that we determine. And we'll create some kind of a formula so that we know what that value is. And we want that reduced to a written contract. If we have a well-written contract and we cover all the bases and we dot all the I's and cross all the T's, then that contract is going to keep us out of litigation. And the perfect contract is the contract that keeps us out of litigation. So the biggest question everybody has is, okay, what's my family going to get from my practice? What's the value of my practice? That's the big question. That's the very important question. And so we could sit down in a document and say, okay, we're going to have the fair market value and we're going to use GAAP accounting, GAAP, generally accepted accounting principles, to figure out the fair market value of my practice. Well, that all sounds really good and looks nice on a piece of paper, except nobody does their accounting based on GAAP. That's only done by large companies that have to get opinion audits from major accounting firms. And so none of our books and records are going to be in compliance. Secondly, I don't know what fair market value means. Well, I've done a lot of tax litigation in my life, and I've done a handful of litigation matters that involved values in estates. And we think the value is X, and the IRS, with their appraiser, always thinks that the value is significantly more than X. And so we have to battle it out. Is the value X, or is the value some multiple of X, and work it out? So fair market value isn't really a very good predictor. And it's not a good way to stay out of court. It's a great way to get into court. And in these kind of litigations, it's great for me or Hanny or Sephora. It's great. It's not good for you. It's not good for the clients. It's not good for the families. Lawyers get paid. For lawyers, litigation for me is like surgery for a surgeon. For them, it's what they do. They understand it real well. They love it. But for me, when we get into the litigation route, it's great for us. We know what we're doing. We love it. This is how we make our money. It's a game for us. It's a chess match. But for the poor clients that are suffering through this thing and paying our bills, it's not the best use of their time, money, or lifeblood that they will lose in that litigation. And so in our contract, if we can have a formula, let's say X times gross or X times net, or some formula that where we can sit back there and we say, we take X, multiply it by Y, that gives us Z. This is the number. No matter how you carve it up, Z is the number. Even if it's not the highest value that we could possibly get, it's a good value, and it's a value that's not going to find us in court if we can agree to it. So that's one of the things we wanted to have in our documents, is as much certainty as we possibly can. The second thing, and maybe the most important thing that we want to have here, is we want to have written out precisely what the notice procedures are going to be, who's going to notify whom. And I'm going to want, if I'm the solo, I'm going to want to make sure that my family and everybody that's involved in my affairs knows precisely who to call and when, and then have a procedure in there so that those that are taking over my practice will be able to do so diligently, quickly, effectively, be able to contact the patients immediately. And so there'll be this seamless, if you will, transition, as seamless as possible between me and whoever's going to take over the practice, recognizing that patient care has got to be of primal importance. We want to make sure that patients are well taken care of in this scenario. And then we can also take a look at all the other issues. Perhaps it'd be better if those other persons that are taking over my practice as a part of the contract, they have the responsibility for notifying the medical board, the FDA, the insurance carriers, and so forth. Perhaps even in that deal, maybe we can contemplate whether it would be better for me to sell my accounts receivable at a discounted rate and my family be done with it for a sum certain, or do I want to continue to hold on to those accounts receivable in the hopes that I can collect them?
And you also want to make sure that they also continue with the tail coverage for you for another 365 days.
Absolutely. That'd be another point that you would want to have in the contract. So that's the optimal. The optimal is that you've got a contract with somebody so that there's a seamless transition. Another possibility, and the contract protects against the immediate, the unexpected. The contract protects against me being out on my motorcycle, I'm healthy, I'm vibrant, and then all of a sudden I'm not. As we're looking to retirement, so as you younger folks start to get a haircut that looks more like mine, what you can consider is bringing on a young physician, a junior physician, in a transition period. And maybe you would like to have a transition period that's like in the 4 to 6 year range, because you want a try-on period. You want to make sure this is the right person to take over your practice. And then you want to, again, have a written buy-sell agreement between you and this person that's coming in, the junior person coming into your practice. There's a number of benefits for this. One of the benefits is that you're going to know that this person knows about your practice. They practice the way that you do. You've got some assurance that the way you practice is going to continue into the future. You have a good chance to mentor these folks for a couple of years, and you have a good chance to introduce them to your staff, your patients, hospitals, other professionals, other groups that you're involved with. And you've got a great chance to let this junior physician know your practice inside and out. And you can bring them on with the stipulation that they're going to buy your practice out. You're going to have a price for it. And you can determine whether you want that to be a scenario where they need to go to the bank, or whether you're willing to be the bank. In other words, whether you're willing to finance this, a portion of this practice. And so when we're looking at that, when we're looking at how we're going to pay for this, we need to look at it from 2 points of view. The departing practitioner wants to get paid. The remaining practitioners, whether they're buying from the outside or buying from the inside, need to make sure they can afford to do it in such a way that it won't bankrupt the business. And so, for example, if you and I were partners, and last time we talked about that $6 million practice, and we had the $6 million practice, and then something happened to me and you had to cut my wife a check for $3 million, that'd be painful. If you had that check within 30, 60, 90 days, that'd be very painful.
Yeah.
On the other hand, if it was a scenario where, okay, fine, you're going to make a down payment and then you're going to pay her the balance over 10 or 15 years or something like that, or maybe we'll do a 20-year amortization with a 10-year balloon or something, that's going to be a lot more palatable. And so you can work out the financing in ways that make sense. And those are things that everybody can take a look at. And then we can also talk to the financial professionals to see if they have any ideas on how we can finance it.
Generally, Don, that's when you're looking at somebody who's older, right? I mean, it's when you're saying, okay, you know, I'm 65, 70, 75, I'm going to retire. Let me bring on some new person to take my spot. I mean, I just had a scenario a little while back where a physician, a doctor, a female physician, she was an OB-GYN doctor in Santa Ana, which is a, you know, it's a pretty busy town in Orange County. She passed away. She died. I think it was a stroke, but she was the breadwinner of the family. So her husband was actually, and this was an Arab couple. So her husband was really taking care of the kids and stuff, and just, he had a small job, but nothing, you know, she was the one, and it was $1 million a year practice. So I got a call from her insurance broker, who was a friend of mine, says, listen, can you take over her practice? Her husband is looking for somebody to take over this practice. And I'm like, I don't, you know, that's just not my field of interest. But, and it was, you know, it was a very successful practice, but it was a solo practice. And so there was no plan for succession, or no plan how somebody else would come in and as her husband could continue managing, or something to that effect, where the household could continue to make the house payments and the food on the table and the kids' private schools. And you know, in my industry, this is not a totally uncommon scenario. You know, people die of heart attacks and strokes all the time, but, you know, physicians tend to be amongst those people more often than not. And I mean, it's just what you're describing here to me, you know, is there's so many questions that are coming to my mind. But the one that really sticks out for me is that if there's no tail coverage and someone sues me after I'm dead, okay, then whatever state I left behind for my wife and kids is vulnerable to that 1 or 2 or 3, God only knows how many lawsuits potentially, because people talk to each other, you know, and patients talk to each other.
Right. And the worst part about it is that you are your best witness in your defense.
Right. How do I defend it?
You no longer have a defense.
Yeah, it's hard to defend it when you're dead.
Correct. I mean, we have to, your files will have to speak to us. And the files generally don't speak to us as well as we would hope. First off, most people don't understand cryptic notes.
Right. Or the handwritings of doctors.
Exactly.
Okay, so I see what you're, so for solo practitioner, we probably need a list. Hanny, maybe it's something you can work with Don on, is to have a list of, you know, to-dos, like, right? How do you really protect yourself against these circumstances, which I'm sure, you know, your many, many years, Don, you know, you've had a chance to see and learn from, because it's very dramatic effect on the family. So it's not as simple as saying that, hey, you know what? I mean, you know, when I die, I die. I had somebody, one of my doctor friends tell me that, is that, oh, you know, just open a corporation and I just put all of my stuff in the corporation, and, you know, after I die, it'll be okay. And it was just a very nonchalant attitude about it, you know, and he's a single practitioner, like a single practice, but it could totally really affect a person's family life significantly.
Absolutely. And this gets actually into a topic that we'll be talking about as we go further down the road. And that is, what are you doing with all that money that you're making right now? Because it's great in that $1 million a year practice. It's great that that's $1 million a year practice. And if you have $1 million a year practice and your family is living $1 million a year lifestyle, you're playing Russian roulette. If you have $1 million a year practice and you have a $500,000 or $600,000 a year lifestyle, and you've got planned investment, and now you're looking at other things, putting that money in places where it can work for you and your family and build wealth and build future income, then that's another way to take out the sting a little bit. But for the practice itself, we really have to plan ahead, and we need to find those people that we can rely on, that we can depend on. And perhaps it's a scenario, and I've seen this over the years, where it's a group. So it's not one physician buying out my practice, but maybe there's 5 of us in a group. And the idea is that if any one of us dies or becomes incapacitated, the other 4 will buy out that practice or in parts of that practice to ease the financial burden somewhat. It also increases the value somewhat, because if everybody takes a little bit, everybody can kind of handle a little more, and that's a great scenario. And then what you'll need to do is recruit new members into the group as you go along. And this becomes sort of like your own little insurance company, not malpractice insurance, but kind of like your own little insurance company in terms of business continuation insurance. And it's great. It's a when you can find the right people, it's a great way to work a practice scenario. And again, when you have planned retirement, then you can bring in the junior. So if I'm 65 years old and I know I want to stop when I'm 70, I can bring in the junior now and work with them over the next 5 years.
Yeah. I received the question, John, Don, basically, what if, I mean, for example, you know, doctor owns a successful practice, owns a real estate, and then, you know, potentially maybe owning a management company where the non-physician spouse, where you put in the non-medical assets, for example, the real estate in a management company, potentially owned by the non-physician spouse, where in the event that, you know, the physician dies, you know, you have some of the assets that the non-physician spouse could potentially sell at a fair market value and have more, you know, more potential freedom or say-so on these type of assets.
This is that diversity question. So if you talk to a stockbroker, for example, or a financial advisor, they'll often talk about diversifying your portfolio. And when they're talking about diversifying your portfolio, they're talking about that portfolio that you have with Schwab or Merrill Lynch or whomever you have your accounts with, where you shouldn't just have IBM stock, you should have a bunch of different kinds of stock, diversification. In this particular case, the diversification you're talking about is the diversification of that asset that's the cash cow, that asset that drives the money that comes in, which is the practice, and then those other assets that are the wealth builders, the places where you're putting that money. And it's a great idea, because if we're going to, let's say, buy real estate, which is a great way to invest money. And so if we're going to buy real estate, there's nothing in the law that says that somebody buying real estate has to be a licensed anything. Anybody can buy real estate. And we can train members of our family. There's a number of ways to do this. So for example, let's say we set up a family limited liability company or a family limited partnership, and we can begin to buy real estate. We can bring our spouse in and start teaching our spouses management principles. As our children become old enough and become trained, wise enough, we can bring them in. And so we can build our own successor management just within our own family while we're building wealth. And if we're really cagey about the way that we do it, we can build wealth in such a way that we can even build multi-generational wealth by holding these family investment vehicles, these LLCs or these family limited partnerships, in such a way that we control them, but we don't necessarily own all of them. We allow other family members to have ownership in them as well. And so we can get that appreciation out of our estate. In other words, if we're going to have a large estate, we can eliminate significant estate taxes by planning early, by considering these options when our estates are still relatively modest and it's affordable to engage in that kind of planning. So that's actually a great idea that you brought up. And it's one you and I, Hanny, have talked about a number of times, diversifying the risk and getting those other assets out there where they can help the family.
So are you saying that, Henny, are you saying, or Don, both of you are saying that it's better to actually put the assets into a separate corporation, my medical assets into a separate corporation other than my medical corporation?
Well, with the medical business, there's a couple issues that we have to get past, okay? And to lay them on the table, we have to get past the stark regs. Let's put those off to the side because that's a separate conversation or a separate discussion. But the part of your practice that requires your license is the practice of medicine. Leasing equipment is not the practice of medicine. And so if you've got, in your case, if you've got the x-ray machines or MRI machines, or you've got the PET scan machines, the ownership of those is not the practice of medicine. The practice of medicine is actually taking the scans and then reading and so forth. And in various practice areas, the practice of medicine is actually the delivery of the medical services and the things surrounding that. It's not the ancillaries. And so if you can segregate out the ancillaries from the actual practice of medicine, so long as we don't have a Stark violation, and I can't get into that today. I mean, that's going to be a much deeper, heavier conversation, and I would hope that we would bring in a healthcare lawyer that specializes in those Stark regs for that. But when we get around those, and we can work around those issues, we can address those issues, then to the extent that we can segregate that, what we're doing is we're now driving down that part of our practice that precludes a non-licensed practitioner from running the practice. And it enhances the value of your practice in that way because, if your spouse is sitting there and your spouse has $5 million worth of equipment, well, that equipment is not going to dissipate in value overnight.
Right.
And other folks that are going to come into the practice, perhaps they want to come into the, in your case, the radiology practice, perhaps that you've got a young fellow that wants to come into the radiology practice and he can't afford to buy the equipment, he can afford to lease it from the leasing company that you have.
Right. Okay. That makes sense. Okay. That makes a lot of sense. So what about multiple people practice? So what would you recommend if we have 3 doctors, 4 doctors, whatever it might be in a practice that started the business together. Now we've been doing this for 15 years. And then, what are the liabilities potential for someone to die in that scenario? And what are the ways that you can, essentially optimize for your family, all the hard work that you've done for 15 years, that they actually benefit from it?
Absolutely. And so let's again start with the do nothing approach. Let's start with the worst case scenario. So the worst case scenario is you have practitioner A, practitioner B, practitioner C. They're all in a practice together and they don't have anything in place. They haven't talked about this. They haven't done anything at all. A dies. Now all of a sudden A's spouse or families walking in the door and they want their share. And the share that they want may or may not be reasonable. I mean, in their mind, this is a practice that brings home a lot of money, so it's worth a lot. And so now they've got this idea about what it is they should get. They can't own the interest in the share. They have to divest. They can't own it at all. And I mean, under state law, they just flat out, nobody's a doctor, nobody can own that at all. They have to get rid of it. But they want a lot for it. Now, clearly, they're going to have to give up the assets. So the practice isn't going to have a situation where they have a non-practitioner out there as an owner. But pragmatically, you've got an angry spouse, an angry family, and so what are they going to do? They're going to call me, or they're going to call Hanny, or they're going to call some lawyer, and now the practice finds itself in litigation over something that could have very easily been solved. And so there's your outside. There's your. The other danger that you have is that A isn't kind enough to die. A instead becomes totally disabled, but still a 1/3 owner. And the spouse and the family are still expecting the 1/3 share, despite the fact that I'm not contributing at all to the bottom line. I've actually become an anchor in your practice. I own 1/3 of the practice, but I'm an anchor. I'm bringing in no business. I'm doing no work. I'm doing no anything. And my wife wants her third. And so we have that issue, and that actually can be a bigger issue, but we have that issue right there. I'm still alive, so technically I can still own my shares of the practice, but I can't speak, and so now I have somebody else speaking for me. And
but
so,
what if the person dies? I mean, what if the other two partners don't want to give any shares to the wife who's not a physician anyway? I mean,
she doesn't get shares. She absolutely can't have shares.
So then she's out of. I mean, I guess that's the lawsuit scenario you're talking about.
Exactly. She walks out of your office into mine, and now you've got a lawsuit based on the fact that she's entitled to something.
But what if she can't even afford the lawsuit at this point in time? That's it.
This is a case that will be taken on contingency, guaranteed. Doesn't need a dime. Some lawyers can take 30 to 40%, and they're going to fight tooth and nail because they know. First off, you and I have had this conversation a little bit. One of the first things that the plaintiff's lawyer is going to do is look and see whether or not there's a pot of money to collect a fee from. When they look at that practice, and I've been taking out, say we're doing $1.5 million net a year, and I've been taking out 5, and the other 2 have been taking out 5. And so the lawyer that looks at that knows there's cash in there to pay something, a lot of something. And so the lawyer is going to work really, really hard for 1/3 of a lot. And so now they're going to take that as a PI type case, personal injury type case, or a plaintiff's case on a contingency and fight that fight. There's the risk that you have. So mom doesn't need, or the spouse doesn't need to have a dime. She just has a real good case. And of course, she's going to win a jury trial because she's going to be able to convince the jury that the remaining partners are just a bunch of thieves. That's going to be the argument that she's going to make. Now,
there's a multiple to the 500,000. So it's not just 500,000 that you get the value of 500,000 times X.
Correct. Correct. No, I'm just saying the 500,000 gives the lawyer the knowledge that there's a lot there.
But also the fact is, so for radiology, the multiple we have on a radiology practice is about a 7 to 8 multiple on our EBITDA. So let's just say if I'm bringing home $500,000 from my radiology practice, that lawyer is going to sue the remaining 2 partners for somewhere in the $3.5 to $4 million range. It's
exactly.
Small lawsuit.
And one a third. Yeah, exactly. They're going to want $3 or $4 million.
Yeah.
Exactly.
Okay.
Not going to want it over time.
And if a jury awards it, then the 2 doctors are kind of screwed.
Exactly. Their only option is bankruptcy, which is not a good option.
And on the other side, if this wife doesn't know enough about it and she doesn't really know about suing or not suing or whatever, then she's out of that potential, of that money too. So both sides need to understand it from their perspectives about setting up the insurances properly or the documentations properly, I'm assuming.
All right, but let's remember this. we're not talking now about a malpractice claim.
Right.
So we're not talking about a 365-day period for bringing a claim. We're now talking about breach of contract or fraud, or so we're now talking about that there's exposure to the practice for several years for this lady to be educated on her claim.
Oh.
Think about it. Okay, so we're all familiar with all the commercials we hear. Roundup. Did anybody you know ever use Roundup? Did anybody you know die who maybe used a little bit of Roundup? You might have a claim. Have you ever used, name your product that's now the class action lawsuit of the day product. So people will be educated pretty quickly on whether or not they have a claim. And even if the widow doesn't have any notion that she has a claim, she's got children or grandchildren or neighbors, or somebody knows that she's supposed to be rich because they were rich. And there's your risk. I mean, and it's very, very significant risk. But if there's proper planning, so if in the practice, if the practitioners will get together and have a classic buy-sell agreement, and this classic buy-sell agreement says, hey, if anybody dies or if anybody becomes incapacitated, then this is what's going to happen. And again, we can not use crazy terms like fair market value, but we can use terms like you just mentioned, X times EBITDA, or Y times gross. We can use whatever formula we want to use as long as it's reasonable. One of the dangers you have in these kinds of contracts is that, and I believe it's a danger, is that that business owners, practitioners will create a contract and it'll say that we value the business at, or we value the business using formula X, but we promise every year or 6 months or 2 years to review this formula, review this valuation. And then the document goes in a book, the book goes on a shelf, and nobody thinks about it. And 15 years later, somebody dies, and that formula gives you a price, and the widow thinks that the price is too low, and now we're going to have to litigate whether or not anybody breached the contract because nobody took a look at it in the last 15 years, but we should have updated it 7 times since. And so there's another case of, in my opinion, bad lawyering, bad drafting, because we have some language in there that's designed to create an opportunity for litigation instead of avoiding an opportunity for litigation. We want to make sure we button down things so that we don't create problems for ourselves for the future. And so as long as the practitioners get together, and you can agree to whatever you want to agree on, you can agree to a multiple. So in your particular case, you can agree to a 7 times EBITDA. And everybody can agree what EBITDA is. And you can say EBITDA as determined by the long-term accountant for the practice. So there's no question as to what that 7 times number is. And now you can have some flexibility. For example, you can say that the practice has X number of years to pay that, and come up with a payment formula that's going to allow the practice to survive and the other practitioners to still continue to draw out the kinds of income that they're expecting to draw out of the practice, and still have but if we walk into a windfall, we have the option to pay it off early. Or if we find somebody to replace you, we have the option to sell this contract to a new practitioner who will take over those payments. So, I mean, there's things that you can do. The key is that you do it before it becomes a problem. It's kind of like if we think about insurance. You and I have talked, and so as you well know, that I was just down in Loma Linda being treated for prostate cancer. Well, this time last year, I didn't think I needed any more life insurance. This time this year, I can't get any life insurance. I'm apparently clean, but doesn't matter. When everything was honky-dory and everything was fine and I thought I was great, I couldn't get I could get all the life insurance I wanted, but now all of a sudden things changed and now I can't get it. And so we look at it the same way with the kind of issues that we're talking about here in the practice. When everything's going good, I know everybody's busy, I know nobody wants to take the time, but that's the opportune time to say, hey, we're going to sit down and put something in play to protect all of us in the future. And if we do that, we come to agreement, we reduce it to writing, we get everybody on board, then we cover those issues. Now we know if we're the ones that die, we know what's going to happen to our family and with our practice. We've got language in there that talks about patient care and transmitting the patients from practitioner A to practitioner B, or perhaps in our agreement we say that all patients belong to the practice, but the practice will now go back in and make sure that all patients are notified. The other two, because it's one big practice, the remaining physicians are going to certainly want to make sure that everything's done correctly. We can address these issues about notification, about the DEA, about all the other issues. The other two are certainly going to want to take care of those issues because they don't want anybody to come back and look at the practice as a whole. So it gives a lot more protection and flexibility to everybody that's remaining. So, and it's just one of those things where it's an ounce of prevention is worth a pound of cure.
Wow. You know, and I have two follow-up questions actually, and I'm going to take it back to the sole practitioner. Is there a way of planning in advance, for example, for the sole practitioner in the event of their death or incapacity, where basically, you know, you have asset protection basically for the surviving spouse and the children, that in the event that, you know, that sole practitioner passes, now a creditor is going after the surviving spouse or the children, can we put in place asset protections that could protect the surviving spouse and the children after the death or incapacity of that physician spouse?
And the short answer is that there are things that we can do from a planning perspective that will protect a lot. Can we protect everything? That's going to be tough to protect every dime. But you got to remember, if we keep the malpractice insurance in place for that 1 year period following the date of death, we have just protected pretty much everything, as long as we've got sufficient reasonable malpractice coverage. I mean, if we're carrying the lowest that we possibly can, then we've got some issues there. But if we've got a reasonable malpractice coverage, then we're protecting against a lot, because the real big issue that we're looking at is going to be that malpractice claim. That's going to be the real big potential issue that we're going to have. And if we take those investment assets, for example, that we talked about earlier, where we use the practice to drive the income, and then we take the income and we invest in other places, and we have those investment assets in family limited partnerships, or we have them in family limited liability companies, then we've done a great job of protecting those assets, particularly if we have more than one member partner. So it's, I mean, a great idea is that we start building, again, equity for our children, whether we're having the children with direct ownership interests or whether we're having the children with interest via irrevocable trusts, so that they've got ownership of the equity without really kind of access to the assets themselves. Then those liability protection built into the LLCs and the limited partnerships, in particular the charging order, which is a nifty little thing in the law that basically says they can't go in and take your ownership interest in this entity. They can merely get a charging order, which allows them to stand in your shoes. And it's just that as long as they've got this debt outstanding out there, you're probably not going to make any cash distributions for them to get their hands on during that period of time. So there are significant protections that we can have.
And the second question, and basically for the partner in a group, what would happen to their shares, their ownership, and you know, forget the fact that, you know, the potential conflict, and you know, in the best case scenario that there is no conflict between the physician that just passed away and the partners, but what would happen to that partner, you know, third of the professional corporation shares? Would that percentage go into probate? Now the partners would have to also would have to kind of deal with probate if it's not, if the professional corporation, of the shares are not basically transferred in the name of the trust.
If those shares are owned incorrectly, if those shares are owned individually by the practitioner, and those shares, okay, assuming that we don't have a transfer on death or pay on death attached to those shares, assuming we just have those shares in the name of the practitioner, not in a revocable living trust, and assuming that the value of those shares exceeds 150,000 in California, yes, there will be a probate. Now, probate in California is not a fun thing. Probate in California can be extraordinarily expensive because there's a fee schedule, and I think I alluded to this the last time, but I often refer to what I call my obnoxious hypothetical, which is that if I have a $1 million estate, and so if I have my $750,000 house and I have a $250,000 bank account, everything's in my own name, and I have one child that I'm going to leave that to, then the lawyer's fees in that $1 million probate are going to be $23,000 and change if you look at the schedule. Even though the lawyer has very little to do, they merely need to open up probate, file a couple of documents with the court, and transfer one piece of real estate and transfer one bank account. I mean, there's really not a lot to do there. Not only that, that probate, if we're really lucky, I mean, technically, theoretically, the probate could take about 7 or 8 months, but pragmatically speaking, that probate's going to take 12 to 18 months to do not a lot. Whereas if I have those same assets in my living trust, I don't have probate, we don't have a lot to do. We can get that handled much more expeditiously and much more inexpensively. There isn't $23,000 worth of legal work in that hypothetical, that obnoxious hypothetical. So if the doc's holding the shares in their own, because even if we have this buy-sell agreement is an agreement that says your estate will sell back to the practice or back to the other practitioners these shares of stock that you own. But you're not around anymore, so you don't own them. They're owned in your estate. So the contract, it's a contract that you agree to, but that your estate actually has to carry out. And so it would require a probate estate unless you had a living trust.
One of the analogies that really resonated with me last week's, I remember if you remember, we had a meeting with a dentist, and you had mentioned you'd rather be poked in the eye than having to go through probate. And given that my wife is an ophthalmologist, so that really resonated well, that example that you gave in, but that's kind of between us. But it's really a horrible process, as you mentioned.
And it's completely avoidable in California.
Everything we're talking about really is advanced planning is the key. I mean, you really have to do that. And I know, it's, I mean, it's not something that we think about a lot. Honestly, Don, it's like as doctors, we're typically just like kind of running like chickens with their heads cut off, one place to another, to another, to another. And a lot of the doctors are in partnerships. Some are in solo practices and stuff, but the majority of them are in partnerships. And these things become really a mess if they don't think it through, especially young physician groups nowadays. They just kind of jump in and start doing things. Wow. Okay. I know we're coming up to the time, that was allotted to us, but wow. What's coming up next?
Yeah, so thank you all for that amazing discussion. I mean, that was a lot of information, but very, very valuable. And so any other questions, please just email them. Hanny, can you put up the email address? And then, so, and all of you, the attendees can also email us any topics you guys want to learn about further. And next week, we're going to be discussing how to ensure that your medical practice and management company are properly formed with all the formalities, what type of language needs to be included in your operating agreements to protect against lawsuits, and what type of management contracts and employment contracts are needed to define the rights and obligations of each side.
Oh boy. Okay.
Yeah, no, it's gonna be a big show, but
it's pretty intense, all of this.
Yeah, so I'm gonna go ahead and share the link for basically where you can set up a 15-minute call, free consultation, or basically set up a meeting as well. And then I also set up, I sent my email, last webinar, I also add my email as well into the chat box.
Great. Thank you, everyone.
Yeah.
Thank you, everyone.
Don, thank you so much. That was amazing. That's a lot of information I gotta chew on. So, okay.
Well, thank you.
Okay. We'll see you next week.
All right.
Okay. Thank you, everyone.